Start. Para. The applicant number 2 impugns the judgment and order dated 20/7/2024 passed by the District Judge Aurangabad in regular civil appeal number 117 of 2021 as well as the judgment and order dated 9/9/2021 passed by the civil judge Ahmednagar in RCS number 316 of 2018 by which a decree of eviction has been granted in favor of respondent number 1 plaintiff as per sections 15, 16 (G) of the Maharashtra Rent Control Act, 1999, and the applicant defendant number 2 is directed to deliver vacant possession of the 2 rooms within a period of 1 month from the date of decree. The defendant is also directed to pay rent for 16 months, rupees 900 per month, along with permitted increases. For the sake of convenience, hereinafter parties are referred as per their original status. Para. The respondent is owner of the suit premises. He was serving with sugar factory at Rahuri. He rented out the said premises to defendants who represented themselves to be husband and wife, and that defendant number 1 is in service with police department at Ahmednagar. Defendants paid rent till November 2016, thereafter defaulted to pay any rent. Plaintiff demanded arrears of rent and asked them to vacate the premises since he was in need of the premises for his own use. Defendant refused to do so. As such, plaintiff issued a legal notice dated 28/3/1998, thereby terminating tenancy and claimed arrears of rent for 16 months along with vacant possession of the suit premises. Para. There was no response to the legal notice, hence plaintiff instituted a suit for eviction and recovery of arrears of rent. Defendant number 1 failed to contest the suit. Defendant number 2 filed a written statement contending that although was inducted as a tenant, plaintiff had offered to sell the suit premises to her for a consideration of rupees 7 lakhs. However, later on agreed to sell it for 5 lakhs. Defendant number 2 paid rupees 2 lakhs and requested him to execute the sale deed. However, plaintiff denied on one or other pretext, and now present suit is filed giving false reasons. Full stop. The trial court framed the issues and concluded that defendant number 2 is the tenant over suit property on monthly rent of rupees 900 per month. The trial court accepted plaintiff's claim of his bona fide requirement and also default in payment of rent by defendant number 2. Consequently, passed a decree for eviction under sections 15 and 16 (G) of the Maharashtra Rent Control Act. Further directions for payment of rent along with 4% permitted increases have been given. Aggrieved thereby, defendant number 2 filed appeal. The appellate court concurred with the judgment and decree passed by trial court and dismissed the appeal. Para. Mr. S. D. Jadhav, learned advocate appearing for the appellants, submitted that plaintiff failed to prove service of demand notice of arrears on defendants, hence she has no cause of action to file suit on the ground of default. He would further submit that defendant number 2 is residing in suit premises for last 24 years. It would be difficult for her to relocate at other place. She would suffer greater hardship as compared to plaintiff in case eviction is ordered. According to him, plaintiff has failed to prove the bona fide requirement. Stop.